Good afternoon. Welcome to this session where you get to ask your compliance queries and get answers to them. Now, there are a number of advantages to doing virtual sessions, but the big one today is that none of you have to be in the same room as me. Now, you might see that as a benefit in and of itself, but on top of that, I have an absolutely stinking cold. So you'll be grateful I can't transmit that through the laptop. I apologise in advance for sniffing and coughing, but the mute button will be our friend. Now, ahead of this session, which we did last week at the sort of physical compliance conference, people got to vote on what they wanted to hear about. And there were three topics that came up as the top three people wanted to hear about. And the first one of those was conflict of interests. Then secondly, around reporting misconduct. And then finally, the transparency rules was third. So we're going to try and run through all three of those. If you were really interested in hearing about other of sort of options, one of those was qualifying work experience. I'd recommend we've got an hour-long video on qualifying work experience and a Q&A on that, which is on our YouTube channel, What Law Firms Need to Know. So look out for that. And I also know Johanna and some other people said they're really keen to cover managing succession. We actually covered managing succession at the equivalent of this session at last year's compliance conference, which is still available on YouTube. So let's introduce our speakers. So first up, we've got Julia Oliver, who is our General Counsel here at the SRA. She led on developing our new standards and regulations. She was previously a partner at Field Fisher and has also worked at the General Medical Council. Next, we've got Justine Allen, who's our ethics team manager. She's been providing solicitors with advice on ethics for 2 decades now. Now, it's not just the case that the only way is ethics for Justine, as she has previously practiced as a litigation solicitor. Next, we've got Nabila Zulfikar, who's our chief adjudicator. She leads a team on making decisions on cases, which can include appeals. She's also a solicitor, and she has extensive experience in regulation, having worked for organisations regulating teachers, architects, advertising, and the press as well. And then finally, we have Paul O'Hara, who's our regulatory manager. He visits firms reviewing their work on key areas of risk, but he also was involved in reviewing compliance on the transparency rules. Sadly, like me, Paul is not a solicitor, so we don't quite have a clean sweep of solicitors on the panel. But fortunately, I'll be asking, not answering the questions. I'm Ben Fisher, the Director of Communications here. So how's this session going to work? Well, one of our panelists is going to do a few minutes introduction about the topic at hand, and then it's over to you. This session's only going to work well if we get questions from you. And the way you can do that is you can click on the link below this broadcast, click on there, submit your question. It's always nice to know your name. You can put your name there, but you can also submit questions anonymously. So put those in and we'll try and get through as many as possible. So the first topic we're going to go through is conflicts of interest. I suppose the only final appeal on putting questions through, if you could keep them fairly short and punchy, that would be great. Really lengthy questions that have, with lots of specific case details might not be quite so appropriate for this forum, but put those questions in. But what I'm going to do now is I'm going to hand over to Justine, who is going to talk us a little bit through conflicts of interest, and then we'll move on to the questions. So over to you, Justine.
Lovely. Thanks a lot, Ben. Hello, everybody. So the ethics team receive approximately 30,000 queries a year from the profession, and conflict is consistently one of the top 2 queries, as I'm sure it is for many of the compliance officers who are listening today. So today we'll be looking at conflict and how you can manage them best. So there are 3 ways that conflict commonly arises. Firstly, an own interest conflict, a client conflict, i.e. between 2 or more clients, or the third way, a conflict between the duties that you owe to 2 separate clients, where you hold information from one client that's material to the retainer of another client, and your duty to disclose to one client to keep the information confidential conflicts with your duty of disclosure to the other. So let's look first of all then at the own interest conflict situation. So the calls we get often centre around loans made to clients and gifts from clients. In both cases, it's important to ensure that the client takes independent legal advice. However, there may be situations where that's not strictly necessary. If, for example, the loan has no onerous terms, or there's no need necessarily for them to take separate advice, but you must be satisfied that the client understands what happens on non-payment, and the client must not be vulnerable. With gifts, one matter that we dealt with, a solicitor had received a gift of approximately £200,000 and was to inherit a large estate on the death of a client, and the firm went to great lengths to ensure that they managed any conflict. They ensured the client took independent legal advice and had a letter from the other firm to evidence this. The client underwent a mental capacity test and wrote a letter giving her detailed reasons as to why she was leaving the gift to the solicitor. They managed any conflict by ensuring they took the right steps and they evidenced the steps on their file, which is particularly important to show any mitigating factors. So secondly, conflicts between two or more clients. So this arises when you're acting the same or a related matter for two separate clients. So generally speaking, you would not be able to act where there exists a conflict or where there's a significant risk of a conflict arising in the matter that you're going to be acting, which highlights the need for timely and thorough conflict checks as part of your client onboarding process. In most cases, it's much better for the client if you decline to act for them at all, rather than having to cease acting, often at short notice or with no notice at all, partway through the matter. That can have a significant impact on the client and third parties such as the court and indeed the other side, or other related people who are impacted by that. So what conflicts therefore should you be doing? First of all, is there a conflict at all? Ask yourself, can you act in the best interests of both of these clients? Or would I act differently if I were acting just for one? If you feel that there's no conflict now, consider then, given your expert knowledge of the law and your anticipated outcome of the case, whether there's a significant risk of the conflict arising at a later stage. Always have in mind the potential cost to the client if they're forced to change firms at a later stage or partway through the matter where a conflict does arise, and also the cost to the firm should the client complain to the legal ombudsman, who has powers to make compensation awards against the firm if a complaint's upheld. So lots of good reasons there for you to be thorough and detailed in your conflict checks as part of the onboarding process. There are two exceptions to this rule, however. The first, a substantial common interest. I don't intend to go into these in any great detail now, but obviously those are so fact specific often that they need detailed consideration. And of course, we can pick those up if you want to contact us via the ethics helpline or by email afterwards if need be. But let's just talk generally. So substantial common interest, a clear common purpose, and the conflict is peripheral to that purpose. For example, setting up a business together, but you can't agree the location of that business. The conflict's peripheral and can be sorted separately between the parties and doesn't necessarily affect the transition that you're dealing with. The exception where you shouldn't really be acting, generally speaking, is acting for buyer and seller in the same matter. The second situation rather, is where the parties are competing for the same objective. So this would be used where two or more clients are competing in an auction or a tendering process, and it couldn't be used where two parties are in a dispute over an asset. In both cases, conditions would apply, and won't go into those things in detail here, as I said previously. So the third and final area of conflict that I flagged up earlier on is where you as an individual fee earner are holding confidential information about one client that's material to the retainer of another client. For example, where you're acting for a client in a divorce and another client also in their divorce, and you find out that the wife or husband of the first client is in a relationship with the other client. That's likely to be material information, and therefore you would have a conflict and you would need to cease acting. So what happens if the firm holds confidential information on another client that you're not acting for and you don't know that information, you personally? So if the client's interests are adverse, the firm must cease acting unless the information can be protected by safeguards. Those safeguards must comply with common law requirements. They must be effective, and often it would only be physical separation, for example, of offices, separate IT systems might need to be considered, separate support staff. So as you can see, there are lots of measures that you can put in place to ensure that those safeguards are effective. And you'd need the informed consent of both of the clients. There are, again, some other conditions, but I won't go through those in detail now. So in conclusion, points to remember: always check at the outset if there's a conflict and monitor the situation on an ongoing basis. Can I act in the interest of both of these clients, or would I act differently if I was acting only for one? I think that's all as a general overview then on conflict, Ben. So if there
Thank you, Justine. Yeah, thank you ever so much. That was great. So I'm pleased to say we have had a couple of questions come in, and I think the first question, I don't have a name next to this, but thank you for sending it in, is on: what is your view on acting for a company in which the acting solicitor has an interest, especially if it's a controlling interest? Juliet, do you want to have a go at answering that one?
Yeah, sure. Thanks, Ben, and thanks for sending that question in. It's a really interesting one, because I think as Justine sort of outlined the sort of key parameters of an own interest conflict, I mean, clearly what you'll need to be kind of concerned to make sure is that you're not putting your own interests over that of your clients in any individual situation. And if you've got a financial interest in the company, you'll have to think very, very carefully about where your interest in the company's direction of travel, or what the substance is of the matter that you might be advising on, would sort of impact or bite on what your interests are in that company. So it certainly is something you need to give careful consideration to. And I think that I can think of examples where absolutely it would make you need to step aside or think about making sure that you have somebody independent who can act. So for example, you might be in a situation where you're asked to advise on a matter which might have very significant reputational impacts for the company, which if they materialized, then your interest in the company would diminish. So if you're asked to advise independently on what to do, or whether to report a matter, or how to deal with an issue, which obviously if reported or handled in a particular way might result in some, I'm thinking if it's a data protection issue that might result in some ICO fine that might get headlines, etc., etc. You shouldn't put yourself in a position where actually your interest might be in not taking those steps that would actually be in the company's interest in doing the right thing. There are, however, other situations where it absolutely might not give rise to a conflict. So your interests in the company's growth and health are the same as the company's. So if you're advising on a transaction and actually your interest in the company's are aligned, then that wouldn't cause a problem. I think it's a good question, because it would certainly in any situation you need to be through. And as Justine highlighted at the outset, just always make sure that you can sort of record your thought process. You can point to the fact that you were alive to the issue, and that you consciously took the decision that you were able to act in a certain situation, and having given that due consideration.
Thank you, Juliet. That's great. Unless anyone's got anything to add to that, I've got a question from John Grace, here's a question about the position on helping clients after you've made a mistake. He makes the point that sometimes correcting a mistake can be simple and easier and cheaper for the client. So what's your advice in that situation? Do you need to stop acting if you've made a mistake? Juliet, again, probably go to you on that one first.
Thanks, Ben. Yes, happy to pick that one up as well. We actually introduced some guidance on this issue a couple of years ago now, following a change that we made to our code of conduct, because in November 2019, we introduced the obligation to put matters right when things go wrong, if possible. So really support the thrust of the question that's asked, because absolutely that's something that we'd like to see. The nub of that is, though, it's the obligation to put matters right if possible, and of course it won't be possible to do that if what it does is put you in a position of own interest conflict. That won't be the case in all situations, though. And it may well be that both you and your client are happy that there's a straightforward fix to the problem, and that you're the best person to do the remedial work to kind of fix the problem. So, for example, it might be very easy for you to correct some errors in documents that you sent to the other side of a transaction, or to seek an extension of time from the court where a deadline's been missed, or, for example, to make sure that you've purchased an indemnity to cover a defect in title that arose because of an error. So all of those sorts of things can be done without any difficulties. But the nub is that you won't be able to advise your client on the options for any kind of remedial action, and to kind of carry on and do that work, where one of those options is for the client to recover loss against you. What you might be able to do is to act possibly under a limited retainer if the client gets independent advice on their options. So if something goes wrong, you let the client know and you advise them to take independent advice, and they work through with somebody else what the options might be. And it's possible that you could then carry on and do some of that work to put matters right. But what you'll need to do is be really mindful of the risks there, and consider things like whether the remedial steps will be costly. And if so, whether you're willing to meet those costs on behalf of the client, whether the steps that need to be taken are complex or uncertain and might take you down a route where you'll need to advise on different kind of paths down the road that bring you back into that kind of conflict situation. It's going to be fact specific, but certainly those are the things that you need to have in mind. But there might well be things that you can do if a problem arises that you can quickly and easily fix.
Thank you, Juliet. Justine, I've got one for you. Can I act for a husband and wife on a sale where the couple have gone through a divorce?
So touching on something Juliet raised about the limited retainer, you may be able to act on that basis where it's restricted in terms of the legal advice that you're providing. But of course, in that situation, you'd have to be very alive to any undue influence or any vulnerability of the clients to decide whether that's appropriate to even put in place. So possible, maybe, but you'd have to carefully consider it before you started acting.
And just adding to that, I suppose, and Juliet, whether you want to say, do you have any view on acting for both sides when no fault divorces come into effect? Will that change things? What's our view like to be around that?
Yes, I mean, I think it's a very interesting area, and I'm not a family lawyer, but I do know that no fault divorce is going to come in from April next year, and that the aim is that that's actually going to reduce the grounds of for conflict between the parties, and support the making of joint applications. And my view is this could well encourage the position where a solicitor can act for both parties. And actually, we've seen quite a number of scenarios in the past few years where this has been possible within the conflict rules in any event, where, for example, a solicitor might settle the terms of agreement which have been reached by the two parties, so they come with a sort of a joint position and ask for the solicitor to sort of settle terms, or else where a solicitor or a firm can advise both parties on matters or likely outcomes jointly, so that they can then kind of go away and try and reach their own decision about the best thing to do. So we've seen quite a few sort of new ways of working and ways in which that can actually work. And I think this is only going to increase, and the new provisions will help to kind of support the idea that there's quite a lot that parties might be able to do jointly to try and achieve sort of a streamlined outcome. I think the kind of key things, again, kind of going back to the key principles and the issues that Justine outlined, is to make sure that you've considered your disclosure obligations. So to make sure that you're able to give full disclosure of any relevant information to each party, so that there needs to be no expectation of confidentiality in respect of the other party. And the need to act in the best interest of each client. So, you're satisfied that you're kind of willing and able to, they're willing and able to instruct you, rather. There's no undue influence on either side, or there's no reason why you might be at risk of entering into any areas of negotiation between the two parties.
And we've got another question that's come in, so thank you for this one. Again, there's not a name next to it, but this person's asked, could you bow out of a transaction if you can't get comfortable with your own anti-money laundering or other obligations being satisfied, i.e. bow out on the basis of an own interest conflict? Justine, do you want to go?
I was going to say, shall I pick that up? Okay.
Yeah.
Yes, of course. I mean, you've got to be able to act competently in any retainer and give due consideration to all of your regulatory objectives or obligations and your legal obligations, such as satisfying yourself about your money laundering regulations, you'll know your client. So if you don't feel comfortable, which was what the questioner was asking, for whatever reason, then of course you shouldn't start to act, or unless you can take steps to satisfy yourself by making further inquiries or asking for further information from the client. So as I touched on when we in the introduction, it's all about making sure that you ask all the information that you need to at the start of the retainer, rather than taking it on and then deciding that you can't act.
And I suppose then, if you did start to act, but you didn't have perhaps some information that made it clear there was perhaps an own interest conflict, if you only discovered that halfway through, which wouldn't be ideal, but let's say that's the case, again, should you consider bowing out in that scenario?
Absolutely, yes. I mean, it all depends on the facts and what it is that you're not comfortable about. And this is what we do every day on the ethics line. So have a chat with us. It's issues that come up fairly often, perhaps for us, but might be just once in a blue moon for the solicitor who's in that situation. So that's what we're here for. And we'll talk through the things that you're uncomfortable with and see if we can find a resolution so that you can continue acting. But absolutely, if you can't, then you can't. And it's about managing the expectations of the client, explaining the reason why, so that you avoid any dissatisfaction.
Okay, we've got a question from Harry, so thank you for that, Harry. Can you act for two companies which are competing for the same objective but are both directly owned by the same person?
Shall I take that one?
Or just Juliet? You go first, Justine, and Juliet, you chip in if you want to add to it.
Okay. I was going to say, this is really about who is my client, because in this situation you're acting for two companies, aren't you, rather than an individual. So you would have to think about, if you've got two companies where there are different share owners, perhaps you might have to think about the best interests of that client, and it might be different in each case. So it's one of those where it depends, but it is all about knowing and thinking about who is your client here to decide who your duties and obligations are to.
Okay, that's great. Do you want to come in on that one, Julia?
Yeah, because I think it's a really good question, because it raises that really important point, which is actually identifying who your client is, and actually the importance of doing that right at the beginning of the client relationship, particularly when you're acting for a company or a corporate entity. It may have different subsidiary companies. You may have different parts of a group, or umbrella group of companies. Equally, actually, within an organization, you could have a council, a board, directors, officers. And I think it's really critically important when you start out with the client relationship, understanding who it is that you're acting, because that's critical to identify who the duty is owed to act in their best interests, and therefore when and how it might come into conflict with anything else that you might be asked to do, or with how that kind of transpires. So I think that's going to be something that's going to be very important, particularly when you're dealing with those kinds of group organizations. But then also, actually, you check that at the outset, but keeping it under review with any matter that you're asked to advise on, so you can really be kind of clear, because it's not unusual. I'm sure those who are listening will have been in this situation where you can be contacted on a particular set of instructions or a matter by a particular client or individual in an organization, and you'll need to sort of check your understanding of, actually, is this for the company itself, is this for a particular individual, is this for somebody, a particular part of the group. And it doesn't mean that you can't act for different parts of an organization, because of course you can sometimes have instructions that come from, one part or another part that are very specific. You could be advising different parts of a group actually specifically in different matters. That'll often be the case, and that's often going to be completely normal and appropriate. But of course you're going to need to decide in those situations whether the matter itself is one that risks actually some kind of conflict between the different parts of the group or the different clients who you might be acting for in that context.
Okay, that's great. Did you just want to come in on that, Nabila?
Yes, it was just a small point, which was just a reminder that there's a responsibility on individuals to act independently and in the best interests of their clients, and that needs to remain under consideration and review, as Juliet said. So that was the only point I was going to make.
That's great. Thank you, Nabila. We've got some questions that have come in, but they're quite detailed and quite complex. So apologies if we haven't come to those yet, but we're trying to focus our questions on sort of the high level questions. If you've got really detailed, sort of case specific complex question, then actually that's going to be probably best to pick up with our ethics helpline, which if you're lucky, you may even get Justine if you phone there, although not for the next half hour because she's on this webinar, but otherwise someone will be able to help with that. So one question we've had is, can I act for a client who I have a relationship with, such as a member of my family? Justine, is that one you could answer?
Yes, yeah, absolutely, Ben. It's not prohibited by our rules for you to act in that situation, but you'd have to consider whether you can act independently and in the best interests of the client. And obviously, if you're in that sort of situation, it's something that you'd have to consider very carefully, whether your own interests are impacting on that. And also public perception is a big one to consider there in that situation, but it's not prohibited. So you could act perhaps.
Thank you, Justine. We've just had an interesting question come in, which sounds quite perhaps case specific, but it might be able to give a general answer. I don't know. So this person's asked, is there a conflict where two solicitors are divorced and one comes before the other who sits as a deputy district judge? I presume the question, it's a friend of a friend who's in this situation potentially, but what is there a potential conflict there?
There may be. Obviously, if you're sitting as a judge, you've got that hat on, and it's whether you feel that you should be sitting and ruling on that particular matter. And of course, the MOJ will have their own regulations about that. So that's the issue for that party. The other party, perhaps they need to raise it as an issue, but it's very personal, isn't it? It's down to whether you feel able to act independently, and also public perception.
Yes, and that is important. Juliet, would you like to add anything on the public sort of perception and the principle sort of around trust in the profession?
Yeah, I think this question, when I saw it, it struck me that it might be more about that point that Nabila raised, which is the principle to act with independence, and just to make sure you're kind of really scrupulous about that, because it strikes me that for the for the judicial party, they're just going to need to be absolutely crystal clear that they're able to act with independence in deciding on the case, and of course, as Justine said, there's guidance and there are principles around when you sit as a judge, making sure that there's no perception of bias, there's no perception of lack of independence as well. So you'll need to be able to make sure you're kind of complying with that. And it might be more around that than that there's an own interest conflict, because that would suggest there might be something specific about the substance of the case that you would have an interest in, and I think what the question is driving at is more actually, can you be kind of clear you're able to keep an open mind and an independent mind when you're sitting in that position, and I would suggest actually that I wouldn't say there was any sort of strict bar. I think that often people know and have kind of relationships with people who are on either side in hearings or the judiciary. But I think there is something about just making sure that you're crystal clear, and if in doubt, to declare, obviously, to make sure you're really clear about the situation.
Thanks, Juliet. Nabila, have you ever seen any sort of examples that are relevant to this type of question in your work?
Yes, I have actually. The question reminded me about a case that I was dealing with in the Court of Appeal some years ago, and counsel rang me because our judge was Lady Justice Butler Sloss in that case, and counsel representing the local authority who'd I'd instructed said, "Oh, we've got an intervener in this case, and the intervener has instructed a barrister," and I can't remember his name, but she said, "Oh, do you know who that is?" And I said, "No." And she said, "Oh, it's the judge's nephew." And he continued to act, and he came along and represented the intervener, and the judge made the decision. And I think it was quite well known, although I wasn't aware of who this individual was, but it was quite well known. So in that case, as it happened, she ruled against him, which was great for us. But I think it goes back to the question of what her responsibilities and obligations were, and she was quite clearly aware of those, and made the decision based on the facts of the case and independently. So I've had direct experience of it, and as long as there is management of that perception or potential perception of conflict or bias, as it may be in this case, and there isn't any reason as to why that judge or district judge should declare or recuse themselves from dealing with the matter.
Thank you, Nabila. We've had a conveyancing question come in, so thank you for this one. Can I act for people involved in the same chain but not transacting directly with each other? So two people perhaps at opposite ends of the chain. Justine?
So this is really an issue of confidentiality and disclosure, so a conflict between your obligations, I think. Are you likely, and you'd have to assess this, so are you likely to become party to any material information in one matter that you need to pass on to the other client? And of course, this is a situation where it could arise partway down the chain. So if, for example, there's a hold-up at one end of the chain that's going to impact on the other party down at the other end of the chain, perhaps in terms of their completion date, you'd have a duty to disclose that. But of course you couldn't because of your duty to the client. So that's where you'd have to consider whether it was appropriate to start acting at the outset. Is it likely that that's going to happen? It's possible, but is it likely? And of course the disruption that would cause if there was a problem partway down the line and you had to cease acting for all the parties and they have to start again with a new solicitor. So it's something where you might decide to start acting having advised the client that there's a potential that you could have to cease to act partway through. So it's not an obvious conflict at the outset, but one that could potentially arise. And if you want to be safe to make sure that that doesn't arise, probably best not to start acting at the beginning.
Thanks, Justine. And we've actually had another question which is sort of in a similar ground, so it might be a similar type of answer, but it's two people who are far closer in the chain. Can you act for a buyer and a seller in a property transaction if safeguards are in place, for example, separate fee earners, and client gives informed consent?
So I did touch on this, I think, in my introduction, is that generally speaking, it's not possible in most cases to act in that sort of situation on both sides of a transaction. So let me just clarify. This is where you're acting for different not buyer and seller, where you're acting for different parties in the transaction.
The question was, can you act for a buyer and a seller in a property transaction if safeguards are in place, so perhaps separate fee earners in the business working on it, and client has given informed consent? So that's all the detail we have, I'm afraid.
Okay, no, that's fine, thank you. Generally speaking, that's not a situation where you should be acting for both parties. Very rarely can you have the degree of separation that you would need where in terms of IT and separate offices, physical distance, to be able to have adequate and appropriate safeguards in place for that information. And clearly the parties may well be in conflict in terms of your duties to act in the best interests of both of them. So very rarely, I think, could you act on both sides for buyer and seller in the same transaction.
Thank you, Justine. We are more than half an hour into this session, or halfway through. Thank you, everyone, for sending all those questions in. I think we got through a good number of them, but apologies if we didn't get to your question. We will have a look at those. But as I say, some of them, I think, with the level of detail there, would be a good one to put towards our ethics helpline. So I think now let's move on to our next topic, because I'm keen to get through these other topics. And that was when to report misconduct. So I think Nabila's going to give us a bit of an introduction on that. And then again, if you could perhaps start submitting your questions on when to report misconduct, or you may want to respond to something you've heard from Nabila, and we'll try and get through them. So thank you. Over to you, Nabila.
Okay, thank you. So in this session outline, I'm going to talk about the criteria to consider when reporting misconduct and what to report, the guidance and the resources that we have available to help you, our expectations of you, and finally, when you should report serious misconduct to us. In terms of the starting point, we've set out the criteria or the test for reporting misconduct cases in the codes of conduct. That's both in the Solicitor's Code and also the Firm's Code. And this obligation, it's important to remember, applies to all firms and individuals that are regulated by us. To help you, we've made the language in the codes consistent, and it requires you to report facts or matters which you reasonably believe are capable of amounting to a serious breach of our rules or requirements. So what that means is that you don't need to be absolutely sure yourself that there has been misconduct or to itemize allegations for us. That's something that is our job, and we will do that if we think it warrants investigation. But we ask you to refer matters to us that have come to your attention that are serious enough and that you believe are capable of proof. In relation to what to report, I'm sorry to say there's no list of the types of misconduct that should be reported to us, and we rely on your judgment. However, we don't want and we don't need everything and anything reported to us. That's not in anyone's interests. It's not in your interests because you're not there to act as a postbox, and it's not in our interest for us to consider matters that wouldn't lead to us taking any kind of regulatory action. So you will need to decide whether the issues engage our rules and are serious enough to report to us. So what do we expect of you? As I mentioned earlier, we don't expect you to have gathered all the evidence, formulated allegations, or indeed to have proved any facts. That's something that we will do. But we do expect you to have formed a reasonable belief that the matter is reportable. And that means that it's beyond gossip or suspicion. So it may require you to conduct some form of preliminary or initial investigation to ensure that there is a reasonable belief. We have produced, though, guidance and resources that are on our website that you should familiarise yourself with if you're not already familiar with them. So we have quite a lot of guidance on the question of seriousness, and that's covered mainly in documents such as our enforcement strategy. So that strategy highlights the factors that we will take into account to address whether an issue is serious. So we'll look at whether there's a real risk to the public interest, there's a risk to consumers or clients or the rule of law or the administration of justice, by way of example. The strategy also highlights some of the things that we will certainly want to look at. So things like criminal convictions, confidentiality breaches and the like. Whenever there is a breach, we will look at also the motivation, the intention and the ethics behind the conduct. So we will look at things like, was there a potential lack of honesty? Was there recklessness? Was there an abuse of power? What was the seniority and experience of the individual or individuals involved? Should the person have known better? We'll also look at things like your approach to the issue. Have you undertaken any remedial steps or offered redress, if that is possible and available? And we may also consider things like the environment and work pressures as well. As well as the enforcement strategy, we've got lots of guidance on certain types of behaviour, and we also have topic guides in our materials, as well as warning notices. And the topics that we have covered so far are on issues such as social media and offensive communications, competence concerns, anti-money laundering compliance, and we also have issued warning notices on non-disclosure agreements and dubious investment schemes. So in terms of when to report, we would encourage you, for obvious reasons, to report to us at an early stage. But again, you should have a reasonable belief of a serious breach. If you use your professional judgment and make a reasonable decision one way or another, we won't second guess you. But we would advise you to keep a note setting out the rationale and the reasons as to how you've reached that reasonable belief of a serious breach. We ask you to report early because that will allow us to use our powers of investigation, so we can compel documents or witnesses, and in the most serious cases we might need to take interim action. So for example, we might want to impose conditions to protect the public, and that could be conditions on an individual or on a firm, or in some of the most serious cases we may consider intervention. So finally, if you aren't sure, err on the side of reporting, but do give us a call first. If you have a regulatory manager, then please contact them for advice. And if you don't have one, call our ethics helpline. What we are trying to do in our enforcement work is differentiate between people essentially trying to do the right thing and those who aren't. So I'm going to stop there. Thank you.
Thank you ever so much, Nabila. And before we move on to some of the sort of meaty questions around when to report, we've had one person put a question in asking whether questions to ethics or ethics helpline on issues can remain anonymous or hypothetical. Could totally understand some people may be concerned about, phoning the regulator and identifying themselves. So what's the situation there, Justine?
Absolutely. Well, of course, people can phone us and choose not to give their name when they call us. And also, we do sometimes take emails on an anonymous basis. So there would be not your usual email address used. So absolutely, please contact us, and you don't have to give your name. We don't ask for that and your SRA number when you phone.
Thank you, Justine. So yes, if you want to phone the ethics helpline, it's definitely worth doing if you have a grey area where you want to speak to someone and get some advice on it. So we've had some questions come in, and we've had a question from Tom, but also someone else asking a very similar question, who've asked around growing trends of using reports to pressurize or intimidate a firm on the other side. So this is, I suppose, weaponizing reporting misconduct to the SRA, someone saying they're going to do that as a form of leverage in a dispute with another firm. What's our view on that? Juliet, perhaps you could kick off.
Thanks, Ben. Yeah, happy to kick off on that one. And interestingly enough, this was raised also at the live session that we had when we had the physical event last week as well. And it was really interesting. Anecdotally, at that session, there was a sort of sense that this was becoming more prevalent. And we do certainly have experience. We've heard of concerns raised with us about reports being made to us. Or threats of reports, and that being kind of used as a tactic, often particularly in underlying litigation. And that can happen in a number of ways. So we've heard of the suggestion of people using a report to perhaps try to obtain documents or information that the person making the report wants to use in the dispute, and sort of trying to use our proceedings to get hold of information, or a report being made to delay or disrupt the progress of proceedings, or as a threat, like the questioner suggested, to perhaps pressurize the other party to take a particular action, or not to do something. So this is certainly something that we recognise, really, recognise that it's a difficult issue. And I think there are perhaps a few things I can say that might be helpful, might be reassuring to people listening. I suppose, the first one is just to say that we don't routinely share confidential documents with complainants. So if you're concerned about somebody using our process to try and get hold of something inappropriately, we may need to refer to relevant factors that we rely on in taking a decision to close a matter when we're explaining that decision to a complainant. But we can always discuss that with you, and if there are any sensitivities around any of the information that you need to provide to us, or anything that we've gathered during an investigation, just let us know. So just to sort of deal with that one sort of head off, because we would certainly want to understand that and can have a discussion with you about anything that needs to remain confidential. But on the question of threatening reporting, just to say that if somebody is acting in an oppressive or abusive manner, so perhaps making threats to report just to kind of manipulate or influence an outcome, then that is absolutely something we would consider to be misconduct, and we take action on. Depending on the circumstances, it could be taking unfair advantage of another party in the litigation, or it could demonstrate a lack of integrity. So we, might pursue that under a breach of our principles. So that's just one thing to say. If we do receive a report and you're concerned that that report has been made as part of a sort of a tactic, just to let you know that we carry out a neutral, objective evaluation of any allegations that come through to us. We'll look at the evidence. We need to be able to take our own view, so we will look at it and try and decide whether there's anything in it. You might be surprised sometimes, notwithstanding the fact that there might be a sort of unattractive motive for making a complaint, there is a genuine issue there of concern. We have to make sure that we're kind of comfortable there's nothing we need to take action on. But our team is very used to getting to the bottom quickly where there are baseless allegations. So I'd really hope that you'd feel no sense of threat where you've done nothing wrong, and you would understand that we'll look at it, but we close matter down incredibly quickly if there's nothing there. But as I say, in terms of our kind of core position on this, this is something that we understand, and consider to be misconduct. And we're kind of currently looking actually at our guidance on balancing duties in litigation, and how we explain kind of, sort of tactics around oppressive litigation and that kind of thing. And what we want to do is make sure that we make our position on this really clear, so everyone can understand and take some comfort and reassurance around that. So we're looking at how we can make sure we're putting those messages out more widely.
Thank you, Juliet. We've got a question in from Paul, so thank you for this question, Paul. He says, as a compliance officer, am I required to notify a serious breach by an individual when I know that the individual concerned has made their own self-report? Nabila, did you want to come in on that, or Juliet, you want to come in?
Yeah, well, yeah.
We're in a standoff.
Shall I?
I'll get Juliet. You go first, and Nabila, you tell me whether Juliet's answer's right.
Fantastic. You'll have it in stereo. Yes, no, I was just going to say, from my point of view, there was quite a straightforward answer to this one, which is, no, the issue is we want to make sure that, and part of the point of the reporting rule is that we get information about serious breaches that we need to act on, that we get that so we're able to investigate it, look at the matter, and that people understand their obligations to make sure we're alerted to that information. If somebody else has reported it to us, then there's absolutely, no reason why you need to make a duplicate report. And we won't be knocking on your door saying you should have done it too.
Thanks, Juliet. And Nabila, I presume you agree?
Yes, I agree. And I was just going to say, just record it in your breaches register. We may come back to you as the cult for the firm for further information. But yes, it's not necessary for you to report it twice.
Wanabila, I'm pleased you agreed. Otherwise, this session could have taken an interesting turn. So we've got a question from Sharif, who's asked if a trainee or a caseworker fails to follow office instructions, is it misconduct, and do I need to report it to the SRA? Justine, do you want to answer that one?
Yes, okay, thanks, Ben. So if it's a trainee situation, I suppose what I'd be saying is, has the trainee reported that to their supervisor or to the appropriate person in the firm? And obviously the firm may have a system of management and control for reporting up a line, for example, and then the culp, it might land on your doorstep, and then you make the ultimate report. But of course, an individual can and should, in appropriate circumstances, make a report. So if it's something personal to them, they may want to make the report themselves. So I think the question was, should they? Well, of course you can, and we're happy to receive reports from anybody having regard to any systems, internal systems within the firm.
Thank you, Justine. So thank you for all the questions we've had in on that, and where we've got about 10 minutes or so left, and one, Paul has sat here very patiently, and two, I know some people are very keen to hear about this. So I suggest we're now going to move on to our transparency rules. Paul, do you want to just run through just some of the headlines as to what the deal is on the transparency rules and sort of common areas where we perhaps don't see compliance, and then if we have any final questions on that, we'll try and squeeze those in. So over to you, Paul.
Yeah, absolutely, Ben. Not a problem at all. So yeah, as we've been saying recently, I've been working on the transparency project. So I've been asked to speak about 3 separate things. So who do the transparency rules cover, our approach to enforcement, and then some tips and tricks. So hopefully there'll be some bits and bobs in there for everybody. But before that, just a brief recap really on the transparency rules and what we were trying to achieve. So introduced by the SRA to make sure that consumers have enough information about costs and services to make informed decisions. Ultimately, what services do they need and how much will it cost? So this pretty much underpins everything that we're going to be discussing. So who do the transparency rules cover? Well, at this stage, pretty much everyone. So if you've got a website, then we're going to expect you to provide information about the clickable logo and in addition, complaints information. So there's 3 bits of complaints information. There's your complaints policy, how and when to contact the legal ombudsman, and also how to contact the SRA. Now, if you publish that you work in specific areas, that will also trigger a requirement for additional cost and service information. But this tends to depend on whether you're acting for an individual or for a business. So for individuals, it's things like conveyancing and probate, and for businesses, it's things like licensing or debt collection. Now, it's really important just to say from the outset, we're not actually interested in dictating the amount that you're going to charge or the services that you're going to offer. So that is ultimately completely your decision, and we're going to leave that to you. Instead, what we're interested about is how you explain your charges and your services. So what specific details? So we've probably not got time to go through all the rules today, but I thought it would be useful to go through some of the areas where there's a bit more flexibility that can help you. So as everyone knows, you're required to provide detailed information about your total costs. Now, we know that solicitors will sometimes say to us, well, that's not possible, or it's different from case to case. So it's important to remember that we accept that that is difficult, and so we're also willing to allow an average or a range of costs. Again, you're also required to provide a basis of costs. So once more, a bit more flexibility there. You can either say hourly rate or fixed fee. Finally, some disbursements. So we know that this can be a costly part of the exercise, and we know that it's not always possible to tell people exactly what kind of disbursements they're going to be making. So again, we'll allow an average or a range of costs. Now, I should say at this point, if you haven't got a website, you're still got to make sure that the information is available on the request. So enforcement, well, it has been a really busy year for the SRA, and we've been doing various things, but I think probably the most dominant thing we've been looking at is the transparency declaration exercise. So we have now reached approximately 6,000 firms. We've been sending them information and asking them to confirm that they are compliant with the transparency rules. It's a declaration. It takes around 10 minutes to complete. It's really straightforward and really simple. If you've been needing help about the actual rules, then we've been going to professional ethics, who've been doing a stellar job. But if you've required some additional help about the form or just the process, then our new transparency team has been able to help you with that. Now, as you can imagine, that generates a lot of work in terms of just websites and decorations that we need to have a look at, and that is something that we've been keen to do. So where we found that there are issues, we've been willing to work with firms to make sure that they bring them up to speed and make sure that the consumer has all of the information that is there and relevant. Now, obviously, if those issues persist, then there are a minority of things that we've been looking at where we've had to pass those over for more formal enforcement. As you can imagine, we're also still responding to reports from members of the profession and the public. So again, once more, where we found that there are issues, then we're working with firms to try and put those right. So finally, some tips and some tricks. So I thought what would be useful is if we just looked at the first one, which is just an absolute frequent flyer, and that regards VAT. So you're required to produce as much information as you can about VAT. And what I would say is if you say that you've got total costs of £1,000, we'll expect to see you saying the VAT is at £200 or at 20%. We don't want to see just plus VAT, which I think sometimes trips people up. Now, the final kind of two things I was just going to mention, and this is just to make your lives easier, really, is the first one is, can we contact you? So first and foremost, is your inbox configured properly? So we still receive complaints from law firms saying, oh, you sent us an email, but it's gone into our junk mail folder. And what we'd say is, that is something that is avoidable. We've actually produced some guidance on that as well. So you can go onto our website and look that up. But it's one of those things where I think if you don't get it right, then it just puts a greater pressure on you when we ask you to try and deliver information to us. And then finally, is your email address correct? So all of the information that we use to contact firms is all stored in MySRA, which is obviously provided by firms. So what I would say is if you've not got the information there or your email address isn't up to speed, then actually we're going to find it really difficult to contact you. And that doesn't mean that we won't ask you to take part in the exercise. It ultimately means probably that we'll have to contact you after the event has expired. And then obviously it just puts a lot of pressure on you to have to deal with something at a much shorter notice. Ben, that's me done.
Thank you, Paul. That was a brilliant whistle-stop tour. I'm pleased we got tips and tricks, which I wasn't expecting the tricks, so that was good. So we've got 3 or 4 minutes left, so let's try and rifle through some quick questions. So firstly, can we use automatic quote generators?
So quote generators, indeed you can. So what I would say is not all quote generators are created equally. So there are examples where we'll go and have a look at them and actually you provide all of the information and the actual quote is provided to you as soon as you press the submit button. And we really like these. Consumers really like them, more importantly, and we think that they're absolutely fine. Now, there is an alternative version to this where actually you provide all of the information and then what you're actually offered is a call back or an email at a later date. And we would say that that doesn't currently comply with the requirements. And just some other bits and pieces as well that I know come up regularly. The first one is, I think if we're going to try and use the quote generators, another aspect of this is just to make sure that you get the most out of them. So we know for a fact that consumers don't like to interact with them where you're asking for lots of personal information. So if you're looking to get something more out of your quote generators, just think about what is the minimum amount of information that I need to take from these people in order to provide them with a bit more information. And then the final bit, which is something that we say all the time, is just make sure that you're using nice plain English so that people can get involved with your firm and find out a little bit more about what you're willing to offer them.
Thank you, Paul. Some really helpful tips there. So another question, can you use the clickable logo across more than one website?
Yeah, so that is something that we have requested on a regular basis, and the good news is you can. In terms of actually setting that up, it's really straightforward. There is actually covered by frequently asked questions from our partner Yoshki. So essentially what you'll have to do is fill out a form and then leave 10 working days in order for us to make those changes. But the benefit of this is that you can then have your website with the same badge on there and it'll enable people to verify that your firm is covered by the SRA.
And obviously that clickable logo is all about letting consumers know the extra protections you get from if you use a regulated firm. So I've got another question, sorry, we're last couple of minutes here. Do we have to comply with the transparency rules if we provide conveyancing advice for lenders?
Yeah, so I think this comes back to that idea about depending on whether you're acting for an individual or a business. So individuals, if you're providing and you publish that you provide this information to consumers, then conveyancing is covered by that, specifically residential. But actually, if you're acting for lenders, this would be businesses, and so it's not actually covered. But what I would say is at this stage, it's always worth thinking about, well, what is the regulatory minimum requirement, and actually what is the best way to do this anyway, just in terms of a commercial decision. And I think one of the things that we've noticed actually is that there are lots of firms out there doing a really good job and not just limiting themselves to what is a regulatory minimum requirement, but thinking actually, what can we do about this? And so they're providing costs and service information about a whole different range of areas that actually aren't covered by the transparency rules. And they're doing that because ultimately they get work from it, which is, a commercial reality.
Thank you, Paul. And I think we've got time for one final question. Can we use the clickable logo on emails or letterheads or other paper type documents?
So that's a nice, easy one to finish off. I can give you a short answer, which is no, but I can also give you probably a more well-rounded answer, which is just think about what the clickable logo is for. So it's actually been designed so that it changes. So if you have a look at your own clickable logo, you'll see that the date changes every time you go to it each day. So it's just worth remembering that obviously if you put that in on your website, it's going to work. But if you put it in an email or letter, it won't work. And the other thing is that you won't be able to click on it and it go through and verify that obviously you're being regulated by the SRA. A final thing as well, just make sure that actually you're using the SRA clickable logo. So I've seen lots of people putting a lot of effort into making their own versions of them. And all I would say is thanks a lot for your efforts, but actually you just need to download the code and put that on your website. We offer a range of colours and you can even have it in Welsh as well.
Well, I would strongly endorse that message, not only so there's consistency, but as someone who works on the communication side, I will be out of a job if firms start doing that branding on our behalf. So thank you for that, Paul. We've hit the hour mark, so I think it's time to wrap this conversation up. I want to say a big thank you to our panelists. It's been way easier for me asking the questions than I'm sure it has for them answering the questions. It may have question after question. I hope a lot of you out there got answers to the types of questions you wanted to get answers to, and I hope you found that useful. However, let us know whether you found it useful, and you can do that through, there is a link below this webinar that you can click through and offer your feedback on this session. That's really useful for us to know about, one, what was it covering the right stuff? What would you find useful? Would you like to do this again? And it'd also be useful to hear about what topics you would like to have covered in the future. So do offer us feedback. Thank you again to our speakers. We've got 3 sessions as part of tomorrow's compliance conference, the virtual version. There's in the morning a chat between Clive Myrie, our chair and CEO, and that's a really interesting discussion. We then got a panel on what technology means for compliance, technology, if I can say it correctly. And finally, there's an equivalent version of this session, but on the account rules. So it's your account rules queries, because we know we get loads of questions about the account rules. It's obviously an area that really matters. So it'll be a similar format to this. You'll be able to put your questions in and get your answers live from our panel there. So do tune in to those 3 sessions. Otherwise, I just wanted to say thank you to Matt for the production, as ever, an excellent job there as well. Thank you to the mute button for disguising the 78 cough-ups I did in this webinar, which hopefully you didn't hear too many of. I'm going to go and put my head in some menthol or Lemsip or something, but I hope you do something even more productive than that this afternoon. But otherwise, thank you very much and enjoy the rest of the day.